My name is Jimmy Yang. Today I will talk about Code of Criminal Procedure, Chapter 11, Search and Seizure. So I will read to you the code here. Article 122, if necessary, the person, property, electronic record, dwelling, or other premises of an accused or suspect may be searched. The person, property, electronic records, dwellings, or other premises of a third party may be searched only when there is a probable cause to believe that the accused or the suspect or property or electronic records subject to seizure is there. Article 123. Search of a person of a female shall be conducted by a woman unless it is impossible. Article 124. A search shall be kept secret and attention shall be paid to the reputation of the person being searched. Article 125. If no property subject to seizure is found, a certificate to that effect shall be given to the person who was searched. Article 126. If a document or other thing held or kept by a public office or public official is to be seized, a request shall be made for its surrender, provided that a search may be made if necessary. Article 127. A place which must be kept secret for military purposes shall not be searched without the permission of the officer in charge. Under the circumstances specified in the preceding section, the permission cannot be withheld except for the possibility of a violation of a major national interest. Article 128. A search warrant is required to conduct a search. A search warrant shall contain the following matters: offense charged, the accused or suspect to be searched, or the property to be seized. If the accused or suspect is unknown, the same can be waived. A place, person, property, or electronic records to be searched. The period that the warrant remain valid shall be specified. No search can be made after the expiration date. Search warrant shall be returned after its execution. A search warrant shall be signed by a judge. The judge may specify proper instructions to be followed by the person executing the search on the search warrant. The procedure in issuing the search warrant shall not be open to the public. Article 128-1. During the investigation stage, if the public prosecutor deems that a search is necessary, he shall apply for a search warrant to the court concerned in writing, containing the matters specified in the Section 2 of the preceding article, together with the reason thereof, except for the circumstances specified in Section 2 of Article 131. A judicial police officer, for the purpose of investigating the details of offense committed by the suspect and gathering evidence of the offense, may, if necessary, after obtaining the permission from the public prosecutor, apply for a search from the court concerned. If the application specified in the preceding two sections is denied, the ruling is not appealable. Article 128-2. A search shall be conducted by a public prosecuting affair official, judicial police officer, or judicial policeman unless it is personally made by a judge or a public prosecutor. A public prosecuting affairs official in conducting a search may seek assistance from judicial or police officer or judicial policeman if necessary. Article 129 deleted. Article 130. An accused or a suspect arrested with or without a warrant or detained by a public prosecutor, public prosecuting affair official, judicial police officer, or judicial policeman may be searched without a search warrant. The same shall be applied to the item he is carrying, the transportation vehicle he is using, and the premises within his immediate control. Article 131. A public prosecutor, public prosecuting affairs official, judicial police officer, or judicial policeman may search a dwelling or other premises without such warrant under one of the following circumstances. 1. To arrest an accused or a suspect with or without a warrant, or to detain him, provided that there are facts sufficient to justify a conclusion that the accused or criminal suspect is therein. 2. To pursue a person in flagrante delicto, or to arrest without warrant a person who has escaped, provided that there are facts sufficient to justify a conclusion that the said person is therein. 3. When there are obvious facts to be believed that a person inside the premises is committing a crime and the circumstances are urgent. During the investigation stage, a public prosecutor may conduct a search without warrant or instruct the public prosecuting affair official, judicial police officer, or judicial policeman to do it, and report the same to the public prosecutor general if there are really probable cause to believe that the circumstances are exigent and there are sufficient facts to justify an apprehension that the evidence shall be destroyed, forged, altered, or concealed within 24 hours unless a search is conducted immediately. If the search specified in the preceding 2 sections is conducted by public prosecutor, the same shall be reported to the court concerned within 3 days. If it is conducted by a public prosecuting affair official, judicial police officer, or judicial policeman, the same shall be reported to a public prosecutor of the public prosecuting office concerned and the court within 3 days. If the court decides that the search should not be approved, the court shall cancel it within 5 days. If the search conducted under the Section 102 has not been reported to the court concerned or has been cancelled by the court, the court at trial may declare the scene seized inadmissible as evidence. Article 131-1. A search may be made without a search warrant with the voluntary consent of the person being searched, provided that the person conducting the search should show his proof of identity to the person being searched and put the fact of the consent being given in the records. Article 132. If a search is resisted, force may be used, but such force may not be excessive. Article 132-1. After executing the search warrant issued upon application, the public prosecutor, judicial police officer should report the result to the court issuing the search warrant. If it cannot be executed, the reason shall be explained thereof. Article 133. An item which can be used as evidence or that is subject to confiscation may be seized. To ensure a forced collection, a certain portion of the property of the suspect, accused, or a third party may be seized with discretion as required. The owner, holder, or the custodian of the items to be seized shall bring forward or deliver the item as ordered. The competent authority shall be notified and the registration method shall be used when seizing real estate, ships, or aircraft. To seize creditor's right, a seizure order may be issued to prohibit a collection from debtor or other sanction, and to prohibit the action of paying for the accused or third party. The seizure as implemented under this code has the effect of prohibiting a disposition. It does not impede the CO seizure of a provisional attachment, provisional injunction of civil proceedings, or the enforcement of the final judgment. Article 133-1. A seizure that is not covered by a search warrant should be adjudicated by a judge, except when the item is seized for evidence or the obligee of the seizure target has given consent. In the consent scenario as described in the preceding paragraph, the enforcer shall present his credential and inform the obligee, the seizure target, that he has the right to refuse the seizure and that there is no requirement to give consent against his will, and then a record of his consent response is entered in the transcript. The ruling as referred to in the first paragraph shall include the following information. Case summary, the identity of the person receiving the seizure ruling, and the seizure target description. However, this information may be omitted if the identity of the person receiving the seizure ruling is unknown. Enforcement invalidity and the instruction for suspended enforcement when the validity expires. The judge may also state additional appropriate instruction to enforcer of this ruling. The procedure for issuing the ruling, as referred to in the first paragraph, shall not be made public. Article 133-2. During an investigation, if the prosecutor deems it necessary to apply for a seizure ruling, a written request, including the information as described in paragraph 3, subparagraph 1, and subparagraph 2 of the preceding article, along with the detailed reasons for the request, shall be submitted to the court concerned with making the ruling. If a judicial police officer finds it necessary to make a seizure, he may submit a request to the concerned court for the issuance of a seizure ruling pursuant to the provision of the preceding paragraph after obtaining the prosecutor's permission. If during an investigation, the prosecuting investigator, judicial police officer, judicial policeman deems that there is sufficient cause and urgency for an immediate seizure, then such seizure may be enforced directly. The prosecutor may also command the prosecuting investigator, judicial police officer, judicial policeman to enforce this seizure. The seizure as described in the preceding paragraph shall be reported to a concerned court within 3 days of the execution. If it is implemented by the prosecutor and shall be reported to a prosecutor of the concerned prosecutor office and the court within 3 days of the execution, if it is implemented by the prosecuting investigator, judicial police officer, or judicial policeman. If the court deems that such action is not permitted, the seizure must be revoked within 5 days. If the request as referred to in paragraph 1 and 2 is rejected, the decision shall not be challenged. Article 134. A document or other property in the possession of or custody of a public office, public official, or former public official, which should be kept confidential for official reasons, may not be seized without the permission of the supervisory public office and the public official in charge. The permission specified in the preceding paragraph may not be withheld unless it is contrary to the interest of the state. Article 135. Mail or telegram, which is in the possession of or custody of a post office, telegraph office, or an official thereof, may be seized under one of the following circumstances. 1. If there is a probable cause to believe that it is connected to the case. 2. If it is sent by or to an accused, provided that a mail or telegram between an accused and his defense attorney may not be seized unless it is considered to be evidence of an offense, and it is apprehended that the addressee and addresser may be destroy, forge, or alter evidence, or conspire with a co-defendant, conspire with a co-offender or witness, or the accused has absconded. If the seizure specified in the preceding section is executed, the addressee or addresser of the mail or telegram shall be notified unless it would interfere with judicial proceeding. Article 136. A seizure, in addition to being enforced by a judge or the prosecutor themselves, may be conducted by prosecuting investigator, judicial police officer, or judicial policeman, as ordered by the judge or the prosecutor. If the prosecuting investigator, judicial police officer, or judicial policeman is ordered to conduct the seizure, a case summary should be stated in the given search warrant or seizure ruling. Article 137. When the prosecutor, prosecuting investigator, judicial police officer, or judicial policeman are conducting a search or seizure operation, if there are objects that should be seized in relation to the case but are not listed in the search warrant or seizure ruling, such object may be seized. The provision of Article 131, paragraph 3 shall apply mutatis mutandis to the case as described in the preceding paragraph. Article 138. If an owner, possessor, custodian, property which should be seized refuses to surrender or deliver it, or resist the seizure without justified cause, such a seizure may be effected by force. Article 139. A receipt listing in detail the property seized shall be given to the owner, possessor, or custodian. Seized property shall be sealed up and or otherwise marked. The public officer or public or the official executing the seizure shall place a seal on the property seized. Article 140. Appropriate measures should be taken to protect the property against loss or damage. A person may be ordered to guard seized property which is inconvenient to transport or preserve, or the owner or the other proper person may be ordered to preserve it. Seized property which is dangerous may be destroyed. Article 141. If the seized property is confiscated or forcibly collected, may be lost, damaged, lose value, difficult to keep, or too expensive to keep, it may be sold for its value, and the proceeds and the proceeds of which shall be retained. The sale, as referred to in the preceding article, shall be conducted by the prosecutor if such action occurred during the investigation, and it shall be conducted by civil executing department of a district court at the court's request if the action occurred during a trial. Article 142. Where the retention of the seized property is no longer necessary, the seized property shall be returned to the owner by a ruling of a court or an order of the public prosecutor before the conclusion of the case. Where the seized property constitutes stolen property and is not claimed by any third party, it shall be returned to the victim of the crime. Seized property upon a request made by the owner, possessor, or custodian may, on provisional basis, be returned to the person who made the said request, who shall be ordered to bear the obligation to preserve the property concerned. The owner, possessor, or custodian of the seized property with justifiable cause may request copies of the seized property during the trial stage, accompanied by posting the deposit for the necessary fees in advance. Article 142-1. If the court or the prosecutor deems it appropriate at the request of the owner or the obligee of the seized property as confiscated or forced collected, the court or the prosecutor can rule to set or order a commensurate amount of guarantee money, and after such guarantee money is paid, revoke the seizure. The provision of Article 119-1 apply mutatis mutandis to the deposit, interest calculation, and the return of guarantee money. Article 143. The provisions of the preceding 5 articles shall apply mutatis mutandis to the object that the accused, the suspect, or third party left at the crime scene, or to the object voluntarily submitted or delivered by its owner, holder, or custodian, which has been retained. Article 144. Locks and seals may be broken, or other necessary measures taken to execute a search or seizure. In executing the search or seizure, the premises subject to search may be closed to public, and the person therein be ordered not to leave, or any person other than the accused, suspect, or third party specified in the preceding article may be prohibited to enter the premises. A violator of a restraining order specified in the preceding section shall be ordered to leave or put into the custody of the appropriate person until the executing proceeding is completed. Article 145. When conducting a search or seizure, the judge, prosecutor, prosecuting investigator, judicial police officer, judicial policeman shall present the search warrant or seizure ruling to the people present at such action, as described in Article 148, except in cases where a search warrant or seizure is not required by law. Article 146. Non-occupied or guarded dwelling or other premises may be entered or searched or property seized at night unless the occupant, watchman, or his representative give permission or the circumstances are urgent. If a search or seizure is executed at night, the reason therefore shall be stated in the record. A search or seizure begun during the day may be continued till night. The provision of Section 3 of Article 100-3 shall apply mutatis mutandis to search and seizure executed at night. Article 147. The following premises may be entered at night for search or seizure. 1. A place occupied or used by a person on parole. 2. A hotel, restaurant, or other premises open to the public at night during the period that it is open. 3. A place frequently used for gambling, committing sexual offense against the victim's free will, or committing offenses against morality. Article 148. If a search or seizure is executed in an occupied or guarded dwelling or other premises, the occupant, watchman, or his representative shall be ordered to be present. If in their absence, a neighbor or an official of a nearby self-governing body may be ordered to be present. Article 149. If a search or seizure is to be executed in a public office, military camp, naval vessel, or secret military place, the officer in charge thereof or his representative shall be notified to be present. Article 150. The parties and the defense attorney during the stage of trial may be present at a search or seizure unless an accused is in confinement or it is considered that his presence would interfere with the search procedure. If it is considered to be necessary, an accused may be ordered to be present when a search procedure is executed. The time, date, and place of a search procedure shall be communicated to the person who may be present in accordance with the preceding 2 sections, unless circumstances are urgent. Article 151. If a search procedure is temporarily suspended and the premises shall be locked, and a person ordered to guard such premises if necessary. Article 152. If property which should be seized for another case is discovered while executing a search procedure, such property may be seized and delivered to the court or public prosecutor having jurisdiction. Article 153. The presiding judge, public prosecutor, may request the judge or public prosecutor of the place where a search procedure is to be made to execute such search procedure. If the requestioned judge or public prosecutor discover that the search procedure shall be executed at another place, the judge or public prosecutor of such place may in turn forward such request to the judge or public prosecutor concerned.